You're listening to People, Places, Planet, the official podcast of the Environmental Law Institute, a nonpartisan, nonprofit research and education institute making law work for people, places, and the planet. If you enjoy the podcast and want to support our work, consider donating at eli.org/donate.
Hi, listeners. Welcome back to another episode of People, Places, Planet. We're here with another installment in our Explained series, Safe Drinking Water Act Explained. I'm here with two special guests, Professors Robin Rotman and Camille Pannu. First, we'll talk about the legal overview, and then we'll move into talking about compliance and enforcement applications and implications. And finally, we'll discuss the evolution of the Safe Drinking Water Act. Welcome to the podcast, Robin and Camille.
It's great to be here.
Thanks for having us.
Professors Rotman and Pannu, why don't you go ahead and briefly introduce yourselves?
Sure. Hi, I'm Camille Pannu. I'm an associate clinical professor at Columbia Law School, where I direct the Environmental and Climate Justice Clinic.
Hi, and I'm Robin Rotman. I am an assistant professor in the School of Natural Resources at the University of Missouri.
It's wonderful to meet you both. Can you all say a little bit about how your work intersects with Safe Drinking Water Act?
So I kind of started my career working with communities that did not have access to safe or clean drinking water under what California later passed as their human right to water. And so I worked primarily with small rural communities that didn't have access to safe drinking water to help bring them into compliance with the Safe Drinking Water Act and to help them access funding to improve their drinking water systems. Now that I'm in New York, I primarily work with communities that are dealing with issues related to combined sewage and stormwater overflows, which usually fall under the Clean Water Act, but sometimes have Safe Drinking Water Act implications.
I also began my career working on Safe Drinking Water Act issues. My first job out of law school was in Jefferson City, Missouri, working as the Assistant General Counsel of the Missouri Department of Natural Resources, which is the state environmental quality regulator that has primacy under the Safe Drinking Water Act. And my interest in water spans both drinking water and clean water. A lot of my work right now is focused on non-point source pollution under the Clean Water Act and how it might intersect with drinking water quality.
Thanks so much for explaining your experience with this law. So the interesting thing about the Safe Drinking Water Act is once you dive deeper, it covers a lot of different areas and can get very complicated. Camille, can you give us a quick explainer on the Safe Drinking Water Act? Why was it created and what's some of its history?
Sure. So the Safe Drinking Water Act was introduced in the early 1970s. Prior to its passage, there was not really countrywide standards for determining whether water was safe or not. There had been a number of public health issues and incidences of disease and other illnesses spreading through lack of access to safe water. And all of that had happened kind of in the 60s, and it culminated in the creation of the Safe Drinking Water Act as a way to provide public health and science-based standards for the protection of drinking water so that there would be some consistency across the country. After that, there were a number of amendments that were adopted that helped kind of build out the current framework that we use for understanding the Safe Drinking Water Act and for regulating contamination and all of that. So it includes things like how we test water, how much of a certain, we call them contaminants, what the concentration of a contaminant can be in water, who's responsible for regulating that water, which systems fall within its jurisdiction. And later on, we also get the development of new standards and new funding sources so that we can also get a partnership between the federal government and state governments to create funds to help fund water infrastructure upgrades.
Thank you for explaining a little bit about what the Safe Drinking Water Act, or SDWA, is. So who or what does it actually regulate?
So in short, the Safe Drinking Water Act regulates public water systems. And the definition of a public water system is one that has at least 15 service connections or serves at least 25 people per day for at least 60 days of the year. And if we want to break it down, there's three types of public water systems. One that we're probably all familiar with is a community water system. That's like a public water system that serves the same people year round. So it could be a city or a county utility. There's also, and this one's a mouthful, a non-transient, non-community water system. And this is one that serves the same people for more than 6 months per year. But it's serving just a segment of the population. So that could be a school, it could be a prison. So it's not serving the general public at large. And then finally, we have the transient non-community water system. This is one that serves the public at least 6 months a year, but it's not the same individuals. So this could be, say, at a campground or a store located in a rural area where it's different members of the public who are constantly coming through drinking this water. So again, public water systems is really the touchstone of the Safe Drinking Water Act. I wanted to point out that the Safe Drinking Water Act does not cover bottled water. That's regulated by the Food and Drug Administration. Also, the Safe Drinking Water Act does not apply to household wells, which actually serve about 30% of the US population, primarily in rural areas. But in short, those are subject to state or local regulation, if any. So the main thing about the Safe Drinking Water Act is regulating public water systems. But there's some other things it does that I also want to mention. It prescribes regulations for dealing with lead and copper components in plumbing. It provides for source water protection, so surface water or groundwater sources that are used as a source for drinking water. It provides various avenues for transparency and public participation. And as Camille already mentioned, the State Revolving Fund is a funding mechanism to support community upgrades to drinking water infrastructure.
Thank you so much for that overview. It seems like that could be a major gap, and it actually serves way more of the US population than one would think. 30% is a really large number, so I'm excited to talk about that later. Moving into implementation, which agency oversees the implementation of the SDWA? And do any other actors play a role here in implementation?
Well, the United States Environmental Protection Agency is the main federal agency responsible for implementing the Safe Drinking Water Act. However, just like in a number of other environmental statutes, we have this system of delegated authority, whereby a state or an Indian tribe can apply to have primacy, essentially to be the lead implementation within their jurisdiction. So this actually is the case for 49 states. Wyoming is the only state that does not have delegated authority, and neither does Washington, D.C. I would also note that the Navajo Nation fairly recently received primacy as the first Indian nation to do so.
That's really interesting, and thanks for pointing that out. So, most states do have delegated authority. It's just Wyoming and Washington, D.C. that don't.
So in Wyoming and Washington, D.C., and on all Indian lands apart from the Navajo Nation, the EPA itself is the regulator that implements permitting, standard setting, enforcement for the Safe Drinking Water Act.
And so, what kinds of protections does this SDWA offer?
Well, the touchstone of the Safe Drinking Water Act are the National Primary Drinking Water Regulations. These are legally enforceable limits for contaminants or required treatment techniques that apply to public water systems. And by and large, these National Primary Drinking Water Regulations apply to 6 categories of pollutants. Let me break those down for you. One is microorganisms. That would be like Cryptosporidium, Giardia. These are often addressed through a required treatment technique. The second category is disinfectants, like chlorine, which need to be in the drinking water supply, but only in limited levels. Similarly, the third category is disinfection byproducts. So chlorine can break down into chlorite, into haloacetic acids, and to other compounds that can have negative health effects. So again, those need to be present in limited quantities. The fourth category is inorganic chemicals. Think arsenic, cadmium, mercury. Of course, we don't want high concentrations of those chemicals in our drinking water. The fifth category is organic chemicals. So some examples would be atrazine, benzene, and also dioxin. Now, what's really interesting about the organic chemicals is that historically these excluded PFAS. So there was no regulation for per and polyfluoral alkali substances. But in 2024, the EPA passed the first regulations for PFAS. Those are numerical limitations that apply to 6 PFAS. And then finally, the last category covered is radionuclides, like uranium. And although it's possible that these could be produced through human activity, the main source of radionuclides in drinking water is just the bedrock geology, natural processes where there is some kind of radioactive decay going on in the substrate.
Thanks for expanding on all of those primary drinking water standards. I'd love to hear more about how these standards are actually enforced. Can you tell us a little more about the limits set by drinking water regulations? What's the difference between the legally enforceable limit and the goal?
So we've just gone over the 6 categories of contaminants that are covered under the National Primary Drinking Water Standards. Now I want to break down the difference between the maximum contaminant level and the maximum contaminant level goal. The maximum contaminant level, or MCL, is the enforceable limit that public drinking water supplies must comply with. And it's set as close to the MCLG as possible, but it also considers factors such as costs and limitations of existing technology or treatment. The maximum contaminant level goal is a non-enforceable limit at which no known health effects occur, and there is a reasonable margin of safety for vulnerable populations like young children and the elderly. It is possible for the EPA to grant a variance or an exemption. These come in a couple different varieties. An exemption is essentially an extension of time for a water system to comply with the new standard. So this could apply in the case of the PFAS standard, but in others as well, where they just need more time to come up either with a treatment solution or an alternative water source. There's also special variances available for small water systems. So these would be ones that serve less than 3,300 people, or in some cases up to 10,000 people, if they cannot afford to comply with the National Primary Drinking Water Standard. Now, these aren't allowed for microbial contaminants, but for the other 5 categories, a water system can just show that the costs of compliance would exceed the benefits. And this is something, for example, I'm coming to you from Missouri, where in rural areas, we have declining population and a declining utility rate base. And so there are small systems that are having to maintain their drinking water treatment plant and their distribution network on fewer and fewer funds. And so that might be the type of system to apply for a variance. There's also a general variance, which can be available to a system of any size due to issues with their source water quality. So if there's a problem with the source water quality, and it could be a natural problem, right, like radionuclides, and there's no feasible alternative source of water or treatment technique, the system will still have to serve the public, and so a general variance can be available.
I appreciate that explainer on exemptions and variances. It's interesting to see the localized considerations that are built into this law. However, there are also secondary standards. Could you both tell us a little more about them and what their purpose is?
There are. So secondary standards are standards that don't necessarily affect the health of the person drinking the water, or at least we don't have adequate research to substantiate that there's a risk to your health, but they may still affect how you interact with water and whether or not you find water palatable to drink. So the secondary standards often affect things like the color of your water, the taste of your water, and other aesthetic elements. And sometimes secondary standards over time, as we get more and more public health information, will become primary drinking water standards as well. So oftentimes we call these contaminants of emerging concern, and they end up as secondary standards until we have adequate public health information and data to determine whether we can regulate it further. But like I said, there's a number of secondary standards that are not necessarily related to public health, but still might be related to whether or not you feel like your water is drinkable or enjoyable.
Camille, thank you so much for expanding on the secondary standards. It's interesting to hear how those sort of nuanced aesthetic qualities that humans can perceive can affect whether we trust our drinking water or not, and that those factors can sort of evolve over time as we get more research. Finally, I wanted to ask what kind of interaction the Safe Drinking Water Act has with the Clean Water Act in terms of source water protection or underground injection control.
That is a great question. Let me begin by saying that the Clean Water Act, passed in 1972, addresses water quality in the ambient environment, so like lakes, rivers, and streams. And the Safe Drinking Water Act, passed in 1974, governs public water supplies. So these are 2 separate statutes. At the federal level, the lead regulatory authority is the Environmental Protection Agency. But as we go to the state level, we might see that there's different state agencies that take the lead under the Clean Water Act, usually an environmental regulator, and under the Safe Drinking Water Act, which could be like a health department. So separate statutes, and in some cases, separate regulatory authorities. But a couple areas of common focus are on source water protection, both on surface water and groundwater. States must identify and report to EPA threats to their drinking water sources, and then take measures to reduce these threats. So in surface water, this mostly means limiting access or putting fencing, say, around a reservoir. But it could be expanded to more holistically address non-point source pollution. When it comes to groundwater, the Safe Drinking Water Act has requirements for wellhead protection, which are basically regarding the construction and maintenance of drinking water wells, and also a permitting process for underground injection control, though there is a major exclusion for oil and gas. So thinking holistically, I would say that the Clean Water Act has been very effective at controlling point source water pollution. But today, non-point source water pollution is the biggest threat to ambient water quality. Yes, there's the Section 303D, the total maximum daily load. There's Section 319 of the Clean Water Act addressing non-point source pollution, but these haven't been particularly effective. And so a question I raise is whether the Safe Drinking Water Act and the Clean Water Act could be implemented even by different regulators, but in a more coordinated manner so that protecting ambient water quality is intimately tied to protecting source water quality.
Thank you so much for expanding on that. It's fascinating to hear how these laws can interact in particular areas. So, moving to compliance and enforcement, what entities are responsible for enforcing SDWA and how can we measure compliance?
Sure. So most drinking water systems are regulated directly by the states or by local governments that the states empower to have that authority. So sometimes that could be county public health departments. The goal of regulation and oversight is really to bring systems into compliance. Because systems are providing drinking water and drinking water is so essential to human life, the goal is to provide the safest water possible within the requirements of the Safe Drinking Water Act. But it's not necessarily to punish the water provider unless they're engaged in some pretty egregious activity. And examples of that kind of activity would be falsifying records, making up test results, providing incomplete reporting on purpose. Not things that happen because of lack of capacity, but rather things that are happening specifically to evade regulators. And the way that these agencies tend to enforce things is through letters and visits and consultation with water systems. If they're not able to bring a system into compliance, or if you have an external polluter who has polluted a water system, there are both civil penalties and criminal penalties that may be available. Primarily, the EPA or the state agency who has primary responsibility would be responsible for bringing those cases against potential polluters. In some states, there's a more complex system of enforcement and water protection. This is particularly true in the Western states. And in those cases, if there's a state agency that's specifically tasked to preserving safe drinking water, they might take lead on compliance efforts and on enforcement as well.
Do water systems have any other compliance obligations besides simply meeting limits?
So, one aspect of compliance and enforcement are the self-reporting requirements under the Safe Drinking Water Act. So, let me say, there's a lot of public water systems. You might have noticed that the definition is quite broad. For example, here in Missouri, we have over 2,800 public water systems. So it wouldn't be feasible for the regulatory authority to conduct inspections of every single source every single year. And that's why the Safe Drinking Water Act requires that public water systems do self-monitoring and self-reporting of their drinking water quality. And I can say when I worked in state government here in Missouri, a lot of the violations that we saw associated with public water systems, particularly non-community systems, were reporting violations. The reports just weren't filed. And you might say, well, this is just kind of a paperwork violation. But it's really more than that, because if the reports are not being filed or if monitoring's not being done, there's no guarantee that the water is safe for the public. So in the case of a reporting violation, fines could be assessed. I'd also point out one of the transparency requirements under the Safe Drinking Water Act is that public water systems must provide a consumer confidence report annually to customers so that the customers can learn about their drinking water quality.
Thank you for expanding on that. And my final question regarding all this information about compliance and enforcement. Robin, you were talking about how some counties and some areas, particularly in rural America, have limited resources. And it sounds like a lot of the enforcement that's taking place would require a large amount of human resources with visits and consultations. My question is, if counties or regulators fail at regulating the drinking water, is there anywhere for citizens to seek recourse, like citizen suits?
Yeah, one of the great things about almost all our federal environmental statutes is that they really work in partnership with the public to ensure that they're adequately enforced. There's not enough human power to be able to see all of these systems all the time and to pay attention to everything that could be happening, especially when the reality on the ground might be different from what we see on paper and reporting. And so there's a provision in the Safe Drinking Water Act that allows individuals to bring a citizen suit. A citizen suit is when a person steps into the shoes of, for example, the state attorney general or other enforcement authority and says, there's been a violation of this law. Here's what we think you did wrong. And here's a lawsuit where we're going to require that the courts enforce the law so that people's health is protected. Generally speaking, a citizen suit gives notice first to the government that would be in charge of regulating. So that would be EPA in this case, or the governmental agency rather, to let them know that there's been a violation and that this citizen, whether that's an individual or a group, plan to file a suit. If the EPA doesn't take action within that notice period, then the citizen can go ahead with bringing a lawsuit to enforce the Safe Drinking Water Act. And when those enforcement actions are brought, they're typically brought with a request for some kind of specific relief, usually injunctive relief, to remedy the issue that's threatening people's drinking water.
It's fantastic to know that there is a public involvement component to the Safe Drinking Water Act, should it be needed. Moving on to applications and implications, are there any recent notable developments or rulemakings that implicate or impact the Safe Drinking Water Act?
Yeah, maybe the biggest change that's happened recently is the adoption of a national standard on PFAS and to regulate PFAS contamination. There's also been a petition filed for a rulemaking on the presence of microplastics in water. This is the first time in a really long time that there's been a nationwide standard adopted that is the same across all drinking water systems. And it's been subject to litigation from industry because of the level at which the maximum contaminant level was set and people's belief that this will be expensive for some drinking water systems to be able to come into compliance with. And so that's kind of been the largest recent change. One of the things that's super hard about the Safe Drinking Water Act is that it prioritizes human health and human public health. And so we want the safest drinking water possible for people. But for many of these very small water systems, sometimes the cost of treatment, testing, or just administering their water system can become really cost prohibitive. So every time we add a contaminant to regulate for health purposes, it also adds to the costs and complexity for the system that's doing the administration of water. And we will likely see additional lawsuits related to PFAS going forward, simply because we have a good number of water systems that are going to really struggle to try to come into compliance with the national standard.
So I want to follow up on that thought. With the testing, with the enforcement, with the regulation, how much are we really talking in terms of costs? And then is there funding that communities can seek or help from the federal government? Or is it just sort of a top-down, you must regulate this and you must also find the money to do so?
Yeah, I think it depends a little bit on the nature of how the contamination is in place. So one of the things that is a little tough about the state revolving funds, which are the partnered fund between the federal government and the states to address drinking water systems that are having issues, is that they don't fund your standard ongoing operations. So they're not going to fund your testing in perpetuity or anything else. But let's say you need to change the kind of technology you have available to treat water to bring it into compliance with the rule, then that drinking water revolving fund might be a good source of revenue for you to try to find funding to retrofit your treatment plant, for example. But it's much harder, I think, for smaller groups to be able to use it, often because they don't have the same kind of access to disinfection technology and other technologies for water treatment. The EPA undertook a cost-benefit analysis when it adopted this rule, so it certainly took into account the cost of compliance. Whether it's going to be extremely expensive or not expensive is really dependent on technology and how technology innovates over time, as well as how big a drinking water system is. So the bigger a system is and the more users it has, the more able it is to absorb new costs because it can spread those costs out over a lot of people. But it's really hard for small systems to do that. And sometimes these kinds of regulations can be extremely financially costly if they're really, really small. That said, all these standards are based on public health. So what we're trading for lack of regulation is people's health. And that's what makes it such a difficult needle to thread.
Hearing the complexities of all this really makes me understand how this can put a stress, especially on small water systems, when new contaminants are added. So we've touched on this a little bit, but could you tell us a little bit more about how the SDWA has been challenged in court?
Yeah, the most common way that this is challenged is, funnily enough, not usually from drinking water users. It's often challenged by regulated industries instead. What's unique about the Safe Drinking Water Act compared to other environmental statutes is the vast majority of water service providers who are regulated are often local governments. So we're talking about city systems, county systems, and special districts that provide water. When they have sued, they have typically sued to reverse a contaminant finding or the setting of a maximum contaminant level, or to challenge any other kinds of requirements related to, for example, the kind of disinfection technology you need to provide or the testing schedule and technology. They're all kind of challenges, not to the fundamental authority of the Safe Drinking Water Act, but really to what's regulated by the Safe Drinking Water Act. There are a handful of lawsuits that have also been brought as citizen suits to enforce the act. One of the more notable lawsuits that has been brought recently has to do with Flint's water and with the continued presence of lead in the Flint water system and delays in the ability to remediate contamination to that system. So every now and again, you will get a challenge that is kind of on the side of drinking water users or people who drink water, which is all of us. But more often than not, the folks who are bringing lawsuits are trying to get a policy or a regulation to be rolled back.
I'm just curious. So, which industries are we talking about, and why would regulated industries care?
It's usually water system providers. Those are the ones who are regulated. So we're talking about like a city water system or a county water system. There are also private utilities that provide drinking water to people. Sometimes it's homeowners associations and water co-ops. But we're less likely to be talking about people who are directly polluting. Generally, folks who are polluting source water are covered under the Clean Water Act. It's much less common for them to be charged under the Safe Drinking Water Act. So usually the folks who are challenging rules under the Safe Drinking Water Act are the folks who are providing drinking water. And they're usually challenging the rule because they're operating on really slim margins where they're barely making their operational costs. And so increasing the amount of money it takes for them to operate can sometimes be a make it or break it kind of regulation for some of these systems that are already kind of underwater, no pun intended.
That makes sense. And what role can states or local governments play beyond what is mandated? Can they set more stringent standards than what's outlined in the SDWA?
So yes, there's a number of roles that states or local governments can play. I mentioned earlier that states can apply for primacy or delegated authority to implement the Safe Drinking Water Act at large. So standard setting, permitting, and enforcement. Now, you asked specifically whether states can set standards that are more strict than the federal standards, so more strict than the MCLs. And the answer is yes. Under federal law, the federal standard is like a floor. It's the minimum protections that need to be provided to the public. But if a state wants to introduce a more stringent standard, that's permissible under federal law. I do want to note, though, that in some states, including Missouri, there are state law prohibitions against the state water quality regulator adopting standards that are more stringent than the MCLs. And I think the rationale for this is to keep the cost down, or if it's good enough for the federal standard, it's good enough for the state, and reducing the burdens on the public water supplies. A couple other areas I wanted to touch on where states and local governments have a role. One is fluoridation. So fluoride can be added to public drinking waters for protecting the teeth of young children. There is an MCL for the maximum amount of fluoride that can be found in public drinking water, but there's no federal requirement to fluoridate or not to fluoridate. And I can tell you here in Missouri, we have a state law that said fluoridation decisions are left exclusively to the local government. So the state environmental regulator is prohibited from passing a rule that's either requiring or prohibiting fluoridation in Missouri. Another area states or local governments can play a role is in drinking water treatment plant operator training. And my uncle is a retired drinking water treatment plant operator. We're seeing a lot of retirements in those positions and really a turnover of the workforce. And so states, counties can play a role in providing the training required for the certification, say through vocational colleges. Another area is in public education. So not everyone's aware, for example, about lead piping in the home. home or lead service lines. One might think that the Safe Drinking Water Act governs the quality of the water all the way to the tap, but actually it just requires it until the water enters your household service line. And so you may have something that's threatening your water quality that's just an issue in your home, whether with piping or some bacterial contaminant, and homeowners need to be educated about that so they can put in home solutions if needed, like a point of use filter.
Is that where tenant laws come into play? There's obviously always issues with lead piping across the country. And then I know that there are some laws that can protect tenants' water quality.
You're right. That's true. For most tenants, if they're not receiving adequately potable water, it will fall under the implied warranty of habitability rules for that particular state, which are often in the health code. In some states, in some limited capacities, if you have a multifamily tenant structure, they do also sometimes test from the tap, and sometimes the landowner will be responsible for their internal plumbing being in compliance. But it is true that generally speaking, the initial complaint kind of falls under housing law, and then sometimes it will come back over to the Safe Drinking Water Act, depending on the specific regulations within the state.
It's really interesting to hear about the roles of states and local governments, and I'm curious if there are any case studies that might exemplify this dynamic.
Yes, I wanted to discuss the Des Moines Water Works case. So this is one coming from Des Moines, Iowa, here in the Midwest, where the upstream agricultural operations were contaminating the ambient water that was being used for Des Moines' drinking water supply. One of them is the Raccoon River, and the main contaminant of concern was nitrates. And so the city of Des Moines Water Treatment Works was encountering higher and higher costs of treating their drinking water. As the quality of the source water declined, and therefore the rate-paying public of Des Moines had to pay higher and higher prices for treating their drinking water. And so the Des Moines Water Works sued a network of upstream drainage districts under the citizen suit provision under the Clean Water Act on the basis that this upstream contamination of the source water was driving up costs of drinking water treatment. In the end, this case was decided by the Iowa Supreme Court in favor of the drainage districts, but it was primarily set on state law grounds. And so the question remains open whether public drinking water systems could sue polluters who contaminate source waters.
So I'd like to talk about two different case studies coming from different perspectives of trying to implement the Safe Drinking Water Act. So one example is Jackson, Mississippi, where their water system has essentially been failing. In most cities throughout the United States, drinking water systems were built in the late 1800s or at the turn of the century. And like all things, they need to be replaced and updated over time. But in smaller cities or shrinking cities, it is harder for folks to have the ongoing capital in their budget to be able to make those improvements to their water system. Jackson has had a number of issues with its water system. It has lead pipes in some places where there's lead contamination in the water. Its treatment facilities have broken several times or sprung leaks. Its pipes have been leaking. When it's been subjected to extreme weather events, that's caused damage to the system or knocked out power. And when power goes out, the pumps stop working, which means that you have stagnant water that can then develop different kinds of contamination that wasn't there when the water was flowing regularly. The way that the government has tried to deal with this is the state of Mississippi talked about taking over the Jackson water system and privatizing it, which was heavily opposed by local folks, primarily because of concerns around affordability of water. So one of the things that's so tough is that for the most part, we're not actually paying for water, but rather paying for the cost of the testing, the billing, the treatment, and the power, everything that it takes to move water to us. As a result, most systems are not actually recovering the full costs that they would need to be able to make these kind of periodic repairs or to deal with emergencies in the system. Ultimately, what ended up happening is US EPA got involved to try to help stabilize Jackson's system. It is currently undertaking major renovations and received a large, although perhaps not large enough, allocation from the US Congress to address their pipe problems and their other treatment plant problems. So that's an example of when there was kind of tension between the local water provider, the state, and the federal government. And the federal government had to play a real mediating role to try to preserve the water system there. One of the other issues that Jackson deals with, though, even once it gets its contamination issues under control, is just the color of its water. For the most part, people don't want to drink water that comes out looking cloudy or brown, even if it's not dangerous to their health. And so that's a persistent challenge in people's confidence about their tap water. Switching to a different example, California is a state that has historically adopted standards that are slightly stricter or more stringent than the federal standards, including regulating contaminants that might not be regulated at the nationwide level. One of those contaminants is hexavalent chromium, or chromium-6, which you may know as the Erin Brockovich chemical for folks who've seen the movie. The state issued a new rule. It conducted a cost-benefit analysis, but that rule was later reversed and thrown out after litigation, where the court found that there was not an adequate analysis of the true cost of addressing hexavalent chromium contamination in drinking water. It's one of the more expensive contaminants to treat and can be a little bit challenging, but it tends to be extremely dangerous for the communities that it's located within. And those communities tend to be more agricultural or rural in nature. So you're mostly getting kind of smaller water systems. California will probably go back and try to re-regulate it at some point, but the state did a lot of work in terms of gathering research and data and going through a very similar rulemaking process to how we get contaminants listed at the federal level in order to determine whether this was a contaminant it needed to address because of the unique nature of water issues within the state.
Thank you all for sharing those case studies. I think they're really interesting and exemplify lots of different dimensions of the applications of this law. So finally, to conclude our podcast, I'm curious how the SDWA has evolved since its inception.
Well, one thing that has evolved is the contaminant candidate list, the CCL. So this is a list of contaminants that are not yet regulated, but are under consideration. And so an example was that PFAS had been on this list, and then an MCLG was developed. So this is a way that as we learn more about different sources of contamination, the scope of the National Primary Drinking Water Standards can be enlarged to include those contaminants.
Camille, anything else?
In terms of future developments, I think there's a really great question to ask about technical assistance under the Safe Drinking Water Act. There's been an increasing focus in the federal government, although that may now change, on ensuring that communities that really are at risk have the resources they need to be able to apply for adequate funding to address those problems. That may shift in the future, but I think there's going to continue to be ongoing need. The other thing that I think is kind of exciting is that EPA was beginning to experiment with new approaches to what we would call non-networked water, so water that's not running through a treatment plant. Historically, that's not something that they can fund or they can regulate, but certainly naming Navajo Nation as a primacy agency, for example, is an acknowledgement that particularly in tribal lands, we tend not to have as much access to formal plumbing. And so I think coming down the pipe, we're going to begin to see some innovation there, probably not in the near future, but perhaps over time, we'll see states innovate in that space to help make up the difference.
Robin, do you have anything about future developments?
In terms of future developments, one thing that I wanted to mention is the rise of point of use drinking water treatment. So these are treatment techniques that can be installed in the home, either on a home-wide basis or on each faucet. And these have a benefit of potentially improving drinking water quality in the home. But there's also the risk that if these systems aren't properly maintained, it could actually have a negative effect on drinking water quality. So I'd say they're a double-edged sword.
For example, in California, where they're trying to deal with hexavalent chromium contamination, there are some communities where the recommendation has been to use point of use filtering, which in the short term seems to be effective. But because you have to keep changing your filters, if the state doesn't provide ongoing funding for that or an ongoing program, which it won't, we run the risk that people will then have dirty filters that are clogged with contaminants that then hyper concentrate the amount of contamination in their water in a way that wouldn't have been the case if they didn't have the filters to begin with.
Okay, so that is really interesting. So shifting some of that filtering to the individual level could possibly even cause more harm in the long run.
Yeah, we have some behavioral economic data from areas that do use point of use filtering that it is uncommon for people to change their filters on time. And I think for anyone who has a Brita filter, that's probably consistent. Most people are not changing the filter in their Brita water pitcher on time. And so now imagine that your filter is now on the main pipe that provides water into your house, or it's in your kitchen under your sink. It can become a little challenging for people to remember to change their filters. And it kind of transfers the responsibility for maintaining safe water from the water provider to the individual household.
Yeah, thank you for pointing that out. That is a very important piece of the puzzle. So before we conclude, do either of you have any final thoughts or insights you'd like to share about the SDWA?
reiterate the fact that the Safe Drinking Water Act doesn't apply to private household wells. And again, the rationale for that is that federal environmental regulation is allowed under the Constitution's Interstate Commerce Clause. So there needs to be some kind of interstate component, and household wells are considered just a bridge too far. But those do serve 30% of the American population, and that number is proportionally much higher in certain areas. So as we look holistically at drinking water improvement in the United States, there needs to be a way to bring those private water wells at least into eligibility for some of the benefits of drinking water treatment.
I agree with Robin. They're piloting a well project in California now. It's mostly point of use, but they're focusing on communities that are disadvantaged or low income where it would be more expensive. First, they're trying to just map them, because one of the biggest problems we have is we know that at least 30% of the country is not on a regulated water system, but we actually don't know the extent of these wells, where they're located, unless each state keeps the information, and every state's not as diligent as others.
Well, I'm excited to see where that project goes. That sounds really interesting. It also sounds like that could probably inform a lot of other states who might want to carry out similar projects. Well, thank you both for teaching us a little bit more about the Safe Drinking Water Act. I think a lot of us take for granted that most of us have clear and odorless and palatable water. And it's really interesting to hear a little bit more of the law that regulates the quality of our drinking water, and also where citizens can seek recourse if their drinking water isn't up to standard. So thank you both so much for being on the podcast, and we'll see you in our next episode.
Thanks for having us.
Yeah, thanks so much for having us.
Thanks for listening to People, Places, Planet, the official podcast of the Environmental Law Institute. Our work wouldn't be possible without the support of people like you. If you'd like to learn more about what we do, attend one of our events, or support our work financially, head to eli.org.